So the action for unfair prejudice is found in Part 14 of the ordinance. Okay? So remember that in Part 14, the plaintiff will be a member of a company which includes a non-Hong Kong company. A non-Hong Kong company is a foreign company that is either registered under Part 16 of the company's ordinance or has a place of business in Hong Kong. The cause of action or the claim which should be filed is that the company's affairs are being or have been conducted in a manner unfairly prejudicial to the interest of the members generally or some part of the members, including the plaintiff. Okay? That's the action. The affairs of the company are or have been conducted in a manner unfairly prejudicial to the plaintiff or all members or some subset of members that includes the plaintiff. Okay? And the key, as I said, is to understand what is unfairly prejudicial conduct. So the remedies available under the unfair prejudice action are extremely broad, and it's very difficult to understand if any remedy is not included, right? So we have injunctive relief. We have injunctive relief which can be restrain action or require action. We also have the possibility of the court ordering that proceedings be commenced in the company's name. And you're aware of what proceedings in the company's name are. They will be very similar to a derivative action. Here, the board would be filing the action, so it would be, in fact, the company filing the action, but it's essentially the same kind of action. However, as we'll see in the Shuntak case, this a particular and express provision of the ordinance has been rejected by the court. That's difficult to explain, and it goes back to some roots in the development of the common law and the ordinance in the UK. So we do have judicial decisions which should be obeying the ordinance, but they are not. The Shuntak decision precedes the new company's ordinance. However, this type of relief was also available under the old company's ordinance, so that would not be an excuse. Appointing a receiver or a manager is actually the most common type of relief, a bit like a marriage. So we have a family, and in this family, let's say one spouse is unfairly prejudicial in behavior toward another spouse. And so that spouse goes to court. And essentially what the result would be is to wind up the family. So following this, you have, let's say, an individual with custody of children and another individual with no custody of children. The family is gone. And this is winding up. And it is a very popular remedy. And also when we look at the Young Key case, we'll see that the winding up remedy is exactly the same as a separate request for just an equitable winding up as a straight out winding up remedy, which is not sought under unfair prejudice, but the factual analysis is identical. And then the court can order really anything else it sees fit, and that includes the order that the shares of the damaged member be purchased by the damaging member, that damages be paid to the damaged member, and a host of other types of remedies. So I invite you to read Section 725 carefully. So, as I said, we have this related action, which we'll go into more next week, but you should note that it exists, which is an action to wind up the company because it is just and equitable to do so. That's what you see at the bottom of the page in letter F. And the analysis of whether it is just and equitable to wind up the company is identical to the analysis for unfair prejudice, which could result in the remedy of an order to wind up the company. So this diverges from the derivative action in a way which the case law has made quite clear, although, as I said, the case law has also, in a very difficult way to understand, expressly rejected the wording of the ordinance. Right? So in the Shuntek case, you have the Ho dynasty, right? And Shuntek Holdings, it has inside members of the family and outside members of the family. They have a company in Macau, which is involved in tourism and gambling and is quite profitable. And then there is another relationship with a separate subsidiary, Interdragon. Now, the gist of this, and I encourage you to read it in particular for the discussion of the distinction between unfair prejudice and derivative action. That's why we're reading this case. But in terms of the complaint, essentially what we have here is that the tourism and gambling company, STDM, was generating significant profits but not paying out dividends. And so what the minority members wanted was an order requiring the board of Shuntek to cause the payment of dividends. And the court finds that essentially this is an action alleging that the board of Shuntek is behaving in a manner which can constitute the kind of misconduct which is found as the cause of action in a derivative action. And so therefore it was an abuse of process to use the unfair prejudice action. As I said, the court ignores the fact that the unfair prejudice action specifically includes that proceedings be commenced on behalf of the company against the directors, say, for certain action. So I leave you with these snippets, and please do not limit your reading to these, but make sure that when you're reading the decision, you do understand clearly the context around the snippets that I give you from paragraphs 30, 32, and 34. So, as I said, the core of the unfair prejudice decision will be determining whether there is a type of equitable restraint which has been established in the company, and this restraint has been crossed by the persons who are alleged to have conducted the affairs of the company in a manner which is unfairly prejudicial to the plaintiff member and other members. I won't ask you to read O'Neill. It's a House of Lords decision which has been expressly approved of in Hong Kong, and it's a very long decision, and I give you some snippets from it, and it does go into the essence of the decision quite well. So we have Mr. O'Neill, who is an employee in a construction company, and he begins to become the most trusted employee of the 100% owner, Mr. Phillips. And they reach a relationship where there's something like an oral promise of a 50% shareholding. The company's business declines, and the majority shareholder demotes him. If you have a career in company law, you should be extremely aware of this particular context, that when the cash is flowing, everyone will be friendly. Everyone is happy. When the cash stops flowing, the various parties in the company may, not always, but they may start going at each other's throats. And this is extremely common, the pressure that comes with a downturn of the economy or a downturn of the companies' fortunes within the economy, can place significant pressure and then cause this sort of a lawsuit. Right? So the employee alleges that there was an understanding that he would become more than an employee. He would become a partner in the company. The partner, the sole owner of the company, then alleges that there is no legitimate expectation. Note that the word legitimate expectation as a synonym for the equitable restraint or the promise or the understanding that we're looking at in unfair prejudice has been explicitly rejected in Hong Kong. In Hong Kong, we leave the term legitimate expectation for administrative law, and we leave it out of company law. Right? So here the House of Lords uses legitimate expectation in a way that you'll see the Hong Kong courts using equitable consideration, equitable restraint, or understanding among the members. And so here O'Neill is found not to be the benefit of an understanding with Phillips that O'Neill would become a 50% holder of the company. Right? So here it is one more time in cartoon version. O'Neill is an employee. Phillips owns the company. O'Neill becomes a very trusted and successful employee, and we have some sharing. The relationship gets close. They get closer. They do things together. They work together extremely well. They may go on vacations together, spend time personally together. They get to the point of discussing this partnership, 50-50, and the company begins to drop in its performance. Cash becomes tight. They argue, and Mr. Phillips then places O'Neill back in his former position, although that former position does not look as favorable as it once did. Earlier on, O'Neill was an employee and happy to be a very trusted employee. After what he sees as a promise to become a full partner, 50-50, then this position is not attractive. And that's why we have the suit. However, the House of Lords finds there was no significantly established promise or understanding on the part of Phillips, and therefore the action for unfairly prejudicial behavior was not successful. And here are a couple of the doctrinal snippets that you might want to look at. Again, beware of the use of legitimate expectation in Hong Kong.